Grace and peace, everybody. We're back. You saw the thumbnail, you saw the title, so you know what we're about to do. We are about to get at this Brian Steele's response. ADA Love's response to Brian Steele's motion yesterday, and Brian actually replied again. Okay, so for some reason or another, I'm getting echo in my ears, but it doesn't seem like you're getting it on your end. So it's something that I've done over here. And I was fooling around earlier today trying to improve my live stream, and I don't know what I hit. So I've hit something that has caused my audio to duplicate in my ears. Oh, well, I guess that is what it is. I want to thank y'all so much for hanging out with me on this evening. I appreciate you all. Yesterday, we went over Brian Steele's extremely detailed, well-written motion to not only recuse Judge Glanville, but for an outright mistrial. And he's actually added more to it on today. However, even though she was tardy to the party and she did not meet the time frame that Judge Cross gave her, I'm going to read ADA Love's response to Brian Steele first, and then we'll go back and read what Brian Steele wrote, because I think after you read what ADA Love has done or said, I do think it's going to make actually what Brian Steele wrote make even more sense. I know that sounds weird, but she's actually working for the other team, I guess. Let's just tell the truth, shame the devil. So with no further ado, because we have got so much to do, let's get it. That's me. That's not right. I tell you, man, we got to get technical support over here. Let us go. Let us go. And there we are. Okay, so what we're reading here today, and you see that this was filed in Fulton County Superior Court today at 7:10 at 5:42 p.m. Now, granted, when she asked Judge Cross for 48 extra hours or 2 days more, she was supposed to have this in at 5 o'clock. I'm just saying, not trying to pick at nits, but it is true that she was supposed to have this already in. But let us continue. In the Superior Court of Fulton County, State of Georgia versus Jeffrey Williams. And who's Jeffrey Williams? That is Young Thug, also known as King Slime. Listen to what she has here. I'm not really a fan of this font. I just realized that they have bold and they have regular font. Interesting. I'm not really a fan of it, but it is what it is. I will tell you this though. I've heard other people read Brian Steele's motion from yesterday, and I'm not crazy. Lots of people are saying that that was a well-written piece of work. I even heard people say as much as this is exactly what legal writing should look like. So I'm just saying, not trying to pick on ADA Love or anybody else, but I know yesterday I said that I felt like what Brian Steele wrote was poetic. And I said he's got this call to action at the end of each block. Each paragraph had this call to action. And a lot of people pointed that out. So it wasn't just me. I wasn't just some pre-K law student that's all excited about it. It was really real. So let's get going. Let's go, Jason. State's response to defendant's motion to recuse Chief Judge Orville Glanville in the trial of the above stated case. Introduction. Midway through this now months-long trial, defendant Jeffrey Williams and defendant Diamante Kendrick have each filed a motion to recuse Chief Judge Orville Glanville. Hereafter motions, and defendant has filed a supplement to the motions hereafter supplement. The state recognizes that Chief Judge Glanville has reassigned the motion and that it has been properly reassigned to this honorable court. But the state respectfully submits that at the time of reassignment, Chief Judge Glanville did not make the three requisite determinations. 1, whether the motion was timely filed. 2, whether any affidavit made in support of the motion is legally sufficient. And 3, whether if some or all of the facts set forth in the affidavit are true. Recusal is authorized. Accordingly, it falls to this honorable court to make those determinations. I want to stop for a second. Actually, maybe I'm wrong, but I do remember Glanville saying that everything was filed in a timely manner. And actually, Brian Steele even points that out multiple times in his filing yesterday. And I do believe he makes the legal point, but we'll see what she has to say. This is not super long, so we don't have to worry about it. And of course, I will leave the links to all of these documents down in the description so you can check them out afterwards. I do apologize. I didn't put them in there earlier. As set forth below, though defendant's motions and supplements are in part timely, the affidavits in support of defendant's motion and supplement are in part legally sufficient. None of the facts. So she already says, okay, wait. She said right here that they weren't filed. Basically, they weren't filed on time. Whether the motions were timely filed. If you're already going to affirm that they were filed in a timely manner, what's the point of bringing that up? Because then she goes right here. As set forth in the defendant's motion and supplements are in part timely in affidavits in support of the defense motion and supplement are in part legally sufficient. None of the facts set forth in defendant's affidavits, even if assumed to be true, would authorize recusal. So let's go back and think about what Brian Steele said yesterday. He said it is wrong for a judge to be a part of a prosecution's defense or a prosecution team. He said it is wrong for a judge to have ex parte meeting without letting everyone know immediately, ex parte, as quickly as you can. And she's saying if that's possibly true, she's first of all throwing shade that it is or isn't true, but even more than that, she's saying it wouldn't even matter. It doesn't matter. Then what's the purpose of the judicial code of conduct? I don't understand. And here's her call to action. Defendant's motion and supplement should therefore both be denied. I don't know if underlining is appropriate. I guess so. I've never seen that before. Not like I've seen a whole bunch, so let's just tell the truth, shame the devil, okay? All right, let's keep going. Factual background. The calling of the state's witness, Kenneth Copeland, on June 7th, on June 6th, on June 7th, on June 6, 2024, in response to an inquiry from counsel for the defendants. In this case, the state announced that Kenneth Copeland would be the state's next witness and would be called to testify on June 7th, 2024. After the announcement, the state received an email from John Melnick claiming to represent Kenneth Copeland and instructing the state to cease communications with Mr. Copeland and that Mr. Copeland would be asserting his Fifth Amendment privilege if called to testify on June 7th. Okay, stop for a second. Why, if you got an email from him to say, stop, don't, cease communication with him, why did you not do that? I almost think that Adrian Love, this is going to make her look worse. And again, you're welcome to go through the whole document. We're just going to read the fine body of it. We're not going to get into all of the weeds, but there's a lot of weeds in here. But why did you do that? Because also, I think you heard her say that they didn't know that Melnick was Woody's attorney. But you got an email from him, and we all saw the man standing there in court saying that he was going to assert his Fifth Amendment privilege. So why are you saying this? I don't get it. Let us continue. And if possible, we will try to get to, I'm not certain if it's in Adrian's or if it's in Brian's, but I do think those infamous emails are in there, one of them. So if possible, we'll go over them as well. Oh, by the way, Brian Steele did submit a new witness list. Bonus points if you can tell me who do you think is on the new witness list. Type it in the chat down below. There's 3 names that have been added to it. And if you're a star student of this of this pre-K law class, I bet you know who's been added to the witness list. Go ahead and put them in the chat if you want to. Feel free. Let's continue. Testify against Mr. Copeland was being called to testify against Jeffrey Williams and Shannon Stillwell, who are represented respectfully by Brian Steele and Max Shard. Melnick copied Brian Steele and Max Shard on the communications with the state regarding Mr. Copeland's intention not to testify. Okay. In preparation for trial, Deputy District Attorney Deputy Hilton, along with her investigator, had met with Mr. Copeland on multiple occasions, and at no time did Mr. Copeland state his intention to plead the fifth or say that he was represented by Mr. Melnick. Nevertheless, after receiving Mr. Melnick's email, Deputy Hilton ceased communication with Mr. Copeland until June 7th. But he's represented by Melnick. So I'm going to let him keep going, okay? Pursuant to the Georgia Code, after receiving Mr. Melnick's email, the state presented to Chief Judge Glanville a motion to compel the testimony of Kenneth Copeland, extending immunity to Mr. Copeland for his testimony, and to hold Mr. Copeland in contempt should Mr. Copeland refuse to testify after being ordered to do so by the court after being granted immunity. The court issued an order granting the state's motion. I think it's fair to say, though I understand this like almost forcing them to testify, I totally understand. I get it now. I totally get it. My only question or problem with this is it is very, very clear that Woody did not understand it. So whether or not you had offered him immunity and whether or not he had immunity and whether or not he should or should not have claimed his Fifth Amendment right or privilege or whatever they might have called it, it's fair to say that the man didn't understand. So therefore, maybe you should not put him in that trick bag until you know that he understands it. Maybe really wait and have his lawyer really talk to him or whatnot. But even more than that, maybe, just maybe, it's not the right thing to force somebody to testify. Again, I've talked to several lawyers. I do kind of understand it. So I'm not saying that it's not the right thing, but it doesn't seem like it's the right thing here. The young man didn't seem like he understood. It doesn't. And I don't think, I think he's finessed in other ways, but he didn't seem like he understood what it meant to be immune. But even more than that, they gave him some information that maybe was wrong. So I can understand, look, I probably wouldn't have done it either. I probably would have said, I plead the fifth and kept it moving. But let us continue. On the 7th of June, after court was called into order, Mr. Melnick appeared before the court and informed the court that Kenneth Copeland would be asserting his Fifth Amendment privilege against self-incrimination. I got a question for you. Why was Mr. Melnick doing that? Because Mr. Melnick was his attorney. Why are you pretending like you didn't know he was his attorney? So we see this. He literally stood in front of the court and said, this is what my client is going to do. Just making a point. Continue. In the presence of each defendant currently on trial and each of their respective attorneys, Chief Judge Glanville called Mr. Copeland to the stand to explain to Mr. Copeland that the state had sought and been granted the order of the court pursuant to this code directing Mr. Copeland to testify and extending immunity for Mr. Copeland's compelled testimony. I totally get it. I just don't think he understood. Again, if he understood it, I think he might have moved differently. But also, you all made a lot of errors in your communication. I probably would not have tested. I probably would have done the exact same thing. Judge Glanville, the Chief Judge Glanville, further explained to Mr. Copeland in the presence of every defendant currently on trial and each of their respective attorneys that should Mr. Copeland refuse to testify, he would be held in contempt of court and jailed until he purged himself of the contempt by testifying in court. Mr. Copeland, thereafter stated his intention to testify. Okay, so this is before the first, I plead the fifth. Okay. And Mr. Melnick looked toward Mr. Steele and Mr. Shard and shrugged his shoulders. Okay, is all right. So I guess looking at a colleague and saying, I don't know what to do is a bad thing. Okay. All right. Not a problem. I guess that makes sense. After lunch. Oh, I'm sorry. After motions hearing, the court recessed for lunch. During lunch hour, Mr. Melnick spoke with counsel for the defendants, but at no time attempted to communicate with the state. Okay? But the state communicated with the judge and made no attempt to communicate with the defendants. See? It works. I mean, why are you surprised? I don't get this. But let us continue. After lunch, the jury was called in and Mr. Copeland took the stand. Mr. Copeland cheekily, I like that. I got to give her that. Whoever wrote that, I like that. Cheekily answered a few questions. This is do you want to answer questions? I'm here. How old are you? Grown. All right. Cheekily answered a few questions. And when asked his age in years, Mr. Copeland responded, I plead the fifth. The court allowed no further questioning by the state and immediately excused the jury, held Mr. Copeland in contempt, and ordered Mr. Copeland into custody. In open court, in the presence of all the defendants currently on trial, and in the presence of each defendant's respective attorneys, Chief Judge Glanville informed Mr. Copeland and Mr. Melnick that he would bring Mr. Copeland back into court on Monday, June 10th, to allow Mr. Copeland to purge himself of his contempt. By testifying, Mr. Melnick announced that he would be going on vacation, would in no way be present on Monday, and would appoint a stand-in counsel, Kayla Bumpus, to represent Mr. Copeland in court the following Monday. So I'm just wondering, could they not have said, well, we just won't call Woody on Monday. We just won't call him on Monday. Or, you know what, we'll do it a different way. Well, could they have done that? Did they have to call Woody on Monday? My only question. Because it seems kind of convenient that the counsel that was really a stick in the mud for you is going to be gone. A stand-in attorney who seems extremely capable. Had she known all of what Melnick knew, she might have moved differently. But she seemed like she knew exactly what she was supposed to do, which was just be there for Woody to purge himself of his contempt. However, we all know about the ex parte, and that's the problem. Keep going, Jason. The June 10th meeting, regarding contempt proceedings initiated against Kenneth Copeland upon motion of the state, attend by counsel of Kenneth Copeland, attorneys for the state, Kenneth Copeland, and the Honorable Judge Glanville. Why is this in bold? There's nothing else in bold. So this right here is A, and it's the calling of the state's witness, Kenneth Copeland. And then you got B right here. This isn't even formatted correctly. All right. Okay. Now, so all our players are in place. We got Judge Glanville. We have A.D. Love, A.D. Hilton. We got little Woody in jail. We got Melnick enjoying vacation. And we got Shard, and we have Brian Steele. Max Shard and Brian Steele. All the players are in place. Let's go. On Monday morning, prior to the start of court, and state requested from the court an in-chambers meeting with the counsel for Kenneth Copeland. I need to go back and look. I believe she asked for ex parte on Friday, I thought. But he said he didn't have time, and that's why they started on Monday, because she's making it sound like they're actually in court. Just read this again. On Monday morning, prior to the start of court, the state requested from the court an in-chambers meeting with counsel for Mr. Copeland and the court and the attorney for the state to discuss the contempt proceedings initiated against Mr. Copeland upon the state's motion. Where did this happen? This happened before they got into the gallery, before they came into the courtroom. So this happened somewhere outside of the court. That's all I want to point out, because it does seem like, how did you do this? Because you're not sitting in court and said this in front of Shard and Steele. This is something that happens literally ex parte, because you're not even in the court when you say it. And I'm almost certain I've seen the clip of her asking this on that Friday to say that she wants to have ex parte. And she did say that in open court, but he said, Judge Glanville said no. And I guess this is how they ended up picking up on Monday. Just my little 2 cents. Let's keep going. The court granted the state's request, and upon being directed to do so by the court reporter made a record of the entire meeting. I don't know about that one. The jury's out on that right now. Lots of people are saying it wasn't the whole meeting, that we didn't have the whole transcript. So I don't know about that one, ADA love, especially if they drop the video or the raw file and you can hear it. Yeah, I don't know about that one, but continue. Present during the meeting were ADA Love, Kayla Bumpus, investigators for the state, Chief Glanville, and later Kenneth Copeland and ADA Hilton. All right. And that's how I think when we read the transcript, we all remember Hilton was not there to start with. Kenneth Copeland was being brought in by the deputies. Not a problem. I see a comment right here that she's confusing on purpose. And I got to admit, I do agree with you. Wait, this is not showing up very well. Okay. Note to self. Yeah. I don't think that this is meant to be digested, if you will, by general populace. I think it's meant to be confusing. Just my little 2 cents. I'm a pre-K law student. I know nothing. Continue. Matters addressed during the meeting concerned only the contempt proceedings against Mr. Copeland, and the topics addressed included Mr. Copeland's rights and representation as it relates to the proceedings, Mr. Copeland's obligations under this code, and answers to questions posed by Mr. Copeland regarding matters related to this code, such as the distinction between purging oneself of contempt as addressed by this code and perjury as prohibited by the same code, with the exception of the times where Mr. Copeland was afforded the opportunity to speak with Ms. Bumpus alone. The entire meeting was taken down by the court reporter. Why do you think she bolded that? She bolded it and underlined it. But we already know that there's a high probability that everything wasn't. So why are you doing this? There were things said, I guess, on the record that are not on the record. Why are you doing that? It just seems interesting, because if Judge Krause reads Brian Steele's and then reads this, she's gonna have a major problem, because somebody's not being honest. Let us continue. Brian Steele's defiance of the court's commands and subsequent contempt ruling. All right, so this is the infamous, I am not going to tell you, tell me the name. Who told you? Why didn't you tell me? Okay, that back and forth exchange. So now most of us remember that. I should have, if I was smart, I would have brought the clips in. But continue. After meeting regarding Mr. Copeland's contempt obligations, Brian Steele stood in open court and demanded a mistrial as he loudly and repeatedly hurled at Judge Glanville accusations of misconduct. Stop for a second. If a judge has an ex parte conversation, they must inform the other party immediately. This didn't happen. And also, I think it's fair to say that ADA Love is also not telling the story completely. This is one of those examples where you tell the truth, the whole truth, and nothing but the truth. She's not giving the whole story. Court, I mean, you just make it sound like he just ran in there and started yelling. I think it's wild. Accusations of misconduct, not misconduct. Why aren't you specific, Adrian? Why are you not specific? What was the misconduct? What was it? Was it letting his dog run free in the gallery? Was that the misconduct? Was it not zipping his robe all the way up? Was that misconduct? No, it was the ex parte meeting that you were a part of. Adrian, tell the truth, shame the devil. Continue. Most disturbingly, after accusing the court of illegal activity, what were those activities? Just say it, because she can't say it because she was a part of it. She was a part of the morphing. She was a part of she was an ally, a teammate. What did he call it yesterday? A coffee clutch, shopping buddies, besties. Okay, I might have added those up. I'm sorry. Anyway, what we do know for a fact is Adrian was complicit in this. But she's making it sound like she wasn't there, one, and Brian is just running around here just yelling, misconduct, misconduct. No, they were specific. Say exactly what they were. Because if she says that, it ties to what Brian wrote, because he used the word ex parte. He used the word and gave the code and the misconduct references and so forth. So it's not just, so if she uses ex parte, she knows that that's going to tie her to Brian and what Brian said, in my opinion. Mr. Steele repeatedly disobeyed Chief Judge Glanville's commands to reveal Mr. Steele's source of information regarding in-chamber matters. Nope, not in-chamber matters. Call them what they were. You had a star chamber meeting. You had an ex parte party, and not everybody was invited. That's it. Tell the truth, shame the devil. Come on now, Adrian. After Mr. Steele refused to comply with the court's instruction, the court held Mr. Steele in contempt. Doesn't it just sound like Brian Steele is just wilding out? He just wilding out in the court, just wilding out. For what? Just because today was Monday and I just want to go home, so I'm just wilding out. No. He is saying that Judge Glanville was wrong for having an ex parte meeting without inviting everybody, and then didn't tell everybody when he came in. And please keep in mind, Adrian Love and Simone Hilton are sitting at the table trying to be quiet because they were a part of the meeting. They should have said something. They should have said, hey, yo, wait, hold on. Yeah, we just had this meeting. We need to talk with you and let you know what we talked about. Well, first, I don't even know if they could have did that because they were already wrong for having the meeting off the rip. But the fact that she's actually couching it and languaging it as if she was not a part of it, that's ridiculous. She deserves it. Let us continue. Let us go. Let's see. After defiantly and repeatedly disobeying the court and being held in contempt of court, Brian Steele filed the motion and supplement. Motion supplement for what? Again, like, this is the economy of words, Adrian. You can be wordy in these things. Maybe not. Maybe don't use this font anymore. What is this, carrier font? Stop using that stuff. Use a real font. And go on and explain yourself. Use those words. Look at Brian's work. Use it. Copy his work. Well, if she copied it, then she would admit that she's wrong. Okay, you got my point. Okay, let's go. Argument and citation of authority. No facts set forth in defiance in defendant's motion or supplement authorizes the recusal of Chief Judge Glanville. So nothing. There's no reason to recuse Glanville. None whatsoever. Okay. To warrant disqualification of a trial judge, the affidavit supporting the recusal motion must give fair support to the charge of a bent of mind that may prevent or impede impartiality of judgment. I'm not going to even pretend like I don't think she read what Brian wrote. That's what I think happened. I think she just literally wrote this, and then she said, oh, he wrote a supplement. Let me add supplement on here. Oh, he wrote a motion. Let me add the motion on here. Brian Steele went on and on and on, and we went over it last night. Check out the video that I did last night. We went over it in detail. Even the motion that he wrote, we didn't even get into every last example and exhibit that Brian gave, because it's like 200 pages. And we read almost 50 last night. And she's saying that he didn't give any substantiation for recusal. I think it's fair to say she did not watch this. She didn't read this. She didn't watch my video. I feel offended. An extrajudicial support source and result. I'm sorry, partiality. To be disqualified, the alleged bias must stem from an extrajudicial source and result in an opinion on the merits on some basis other than what the judge learned from the participation in the case. Emphasis added. I just think she's doing whatever she wants to do. I really think she wants to muddy the water, and she's praying against hope, hoping against hope that Judge Cross is as silly as she thinks she is. That's the only thing I can conclude, because I can't see why you would believe that this argument, if for no other reason, because I guarantee you, if Adrian Love was in Max Shard or Brian Steele's seat, she would be having a fit. She'd be having a whole bona fide grandma fit if Brian Steele and Max Shard had gotten preferential star treatment with their witness, and they're able to threaten them, coerce them, and do all this kind of stuff, cajole them to testify, and she didn't know about it. Please stop with the grandstanding. Adrian, stop it. Because we know you would have acted a whole bona fide fool, a whole black girl magic, black girl tragic fool in that court. Because you'd be acting a fool now. DearWokeC@gmail.com. I'm right here in Cobb County. Whatever. Let us continue. There is a presumption that a trial judge acting as a public official faithfully and lawfully performs the duties devolving upon him, determining whether an affidavit supporting a motion to recuse is legally sufficient and whether the facts asserted authorize recusal present questions of law. I don't even know what you're talking about. Are you honestly, do you really want us, Adrian Love, to turn off our thinking and pretend like we didn't see what we saw? Is that what we're supposed to do? I don't know. She needs to maybe put like a little supplement to this thing and say, this is what you're supposed to do. You're supposed to pretend like this is a cogent argument so we can kind of like know how to play the game, because this is insane. We watched you get preferential treatment. We watched you actually get to cajole and threaten and intimidate a witness with the help of Judge Glanville. Not just Judge Glanville sitting there, but he actually assisted you and gave you legal advice. It's in the transcript. That wasn't redacted. I just don't get how does this work? I need Adrian Love to put a how does this work manual together so we can all know how we are supposed to respond to what you write, what you say, because at this current moment and juncture, that doesn't make any sense. That's insane. Continue, please. Here, with the exception of the defendant Williams, untimely allegations regarding a single instance where Mr. Steele was chided by the court for not being prepared. And I'm going to have to find the clip, but I've heard some attorneys explain what is the problem if a judge says that you're not prepared. That is a very bad thing. Let's just say it like that. That's a very bad thing for a judge to say, Attorney Jason, Attorney Butterfly, Attorney Caterpillar, you are unprepared. That is not a good thing. But continue. Defendant's motions and the supplement are based entirely on the defendant's assertion regarding the June 10th. What does this have to do? What does being chided have to do with all of your assertions are based upon the June 10th meeting? Then just stick with the June 10th meeting and use more words to explain what the meeting was about. Maybe use the Latin word. There's a cool Latin word that we've all learned, ADA Love. It's super cool. People have been saying it all the time. Say it with me. Ex parte. That's right, Adrian. If you say ex parte meeting, that is a whole different game of cheese. It's not just a meeting, or we were just standing around the water cooler. If you called it ex parte, it would be a whole different thing. If you said star chamber, it would be a whole different thing. That's why you're not using those words. I'm just saying. Contempt proceedings against Kenneth Copeland and actions taken by Chief Judge Glanville after Mr. Steele defiantly refused to comply with the court's repeated requests to provide the court with information. What information? Or did he want to know his social security number? Did he ask him for his favorite Starbucks order? No, the information was, who told you, Brian Steele, that I, Judge Arvil Glanville, was having an ex parte meeting with these two? That's the information. Call the information what it is. Georgia Code of Judicial Conduct regarding, she uses it, ex parte communications provides that judges shall accord to every person who has a legal interest in a proceeding. So are you saying, again, I don't know why she's bolding and underlining this. Is she saying that Jeffrey Williams doesn't have legal interest in the proceeding? Is that what she's saying? I think that's what she's saying. Poor Adrian, man. She's going to need a hug, y'all. We're going to have to find Adrian and give her a hug because she is going to need it. Oh, my gosh. This is horrible. And I'm trying to be gracious, but it doesn't even make sense. It doesn't even seem like what you're doing here is you're only making an argument out of, I feel like it's an argument out of emotion. I feel like it's an argument that I want to prove that emotionally I'm in control. I got this under control. So I had to make an argument, something, even though I'm not in control. And even though I'm in the whole bona fide wrong. Continue, Jason, continue. Why is this bolded? Or that person's lawyer, the right to be heard according to the court. I don't think that's what we read yesterday. I do think that this right here, a legal interest, they have a legal interest to be in the meeting. They needed to know that little Woody didn't want to testify. He was thinking about testifying to all these other crimes. He was worried about perjury and purging and all of that kind of stuff. They needed to hear that. They do have a legal right to hear that. ADA love. However, no defendant on trial in this case had or has any legal interest in or any standing to be involved in the state's motion to compel the testimony of Kenneth Copeland or any subsequent contempt proceedings initiated on motion of the state involving Kenneth Copeland's refusal to testify. All you have to do is just flip a couple names around and you know that this argument is totally crazy. You know good and well if Adrian Love was on the other side of the table and not invited to the cool kids ex parte party, you know good and well she'd be having a fit. She'd be steaming out her ears. You know it. Why are you even pretending like it's not true, Adrian? Come on, girl. Come on. Somebody give Adrian a hug. We're going to have to put love in the chat. You know what? Let's just put love in the chat. We need love. We need it. We need love here. We got to just drop some love in the chat. Drop a love, a heart, a green heart, a red heart, purple heart, blue heart. We need love in the chat because Adrian Love needs love at this point. Since no defendant in this case, did they change font? Y'all, this font is driving me crazy. I'm sorry. Okay. I'm trying not to be petty, but I can't promise you. No defendant in this case had a right to be present on the June 10th, 2024 in-chambers meeting with Kenneth Copeland and his counsel regarding the contempt proceedings against Mr. Copeland. The fact of the meeting provides no grounds for recusal of Chief Judge Glanville. Respectfully submitted the 10th day of July, 2024. I'm sorry. I disagree with this. So heartily disagree with this. Here, let me grab this real quick and drop this in the chat. If you want to look through it, and like I said, there are a ton of supplements at the bottom. There are a ton. And I just don't want one. No, Regina, we need to. I'm only saying we're going to put love in the chat because Adrian needs a hug, man. Adrian needs a whole bona fide hug. She needs a hug. All right, let me fix this thing. This thing looks crazy. That is not cool. Some reason or another, my eCam is looking real shady tonight. I don't know what happened to it, but I will resolve this after the show. But my eCam is getting real out of control. Okay, so let's just scroll real quick, see what our Exhibit A is. Oh, here's the infamous. Is this the infamous email? Hold on. Y'all just want dear old Christian to say something with the FU in it. That's what it is. I'm trying to see if these are, I don't know how to determine if they're in order. Because I know which one y'all want me to read. Y'all are wild. Okay, this is the June 7th one. Okay, I am not. Okay, so please, there are a ton of emails in here. Okay, but I do want to read this one because this is like the 9th person to ask me about this one. So I'm gonna go ahead and read it. I'm gonna go ahead and tell you. Go ahead and call my pastor. Go ahead and let me get him on speed dial so I can be rebuked. Here I go. This is from Melnick to Hilton and to Love, and it's on Friday, June 7th. So let me just look real quick. When did he talk to him before that? Okay, so they had a conversation. So they even talked on March 3rd. Yeah, there's Melnick right there. Now, granted, anything could have changed, but okay. It's just funny because remember they positioned it as if they didn't know that Melnick was Woody's attorney, but it's clear that it seems here clear to me that they at least were in communication with him sometime before. So they should have at least had an idea, an inkling, like, oh yeah, Jonathan was representing him. Let me reach out to Jonathan and see if he's moving forward. But okay, here it is, y'all. My concern is for my client. Had I been involved, I would have demanded a much more specific immunity deal. You need him much more than he needs you. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go yourself if you think I'm doing anything besides protecting my client. All right. And so this was at 11:56. So 11:53, she says, is your concern for your client or for Mr. Steele's and Mr. Shard's? All right. And then this is the same day, literally, they're going back and forth, man. Here's a communication between myself and Miss Love, which pertains directly to the YSL case. Oh, this is where he actually added other people. Well, let me see. Hold on. This is kind of hard to get. I'm trying to see how it's organized. Because now we're in March. And he says between myself and Miss Love. So that would sound like it's either Melnick or Simone, because those are the only 3 people on here. And now we got Sheila Rosser. But let me go back here. Yeah, this is Simone. So it's from Jonathan to Hilton to Simone. Yeah, I'm sorry, to Hilton and to Love. So how did it get to Brother man. How to get to, I don't see how I got there. Y'all, this is all over the place. Litigation manager, that's who Sheila Ross is. Okay, I don't see when he forwarded to Brian Steele. They got the whole party up in a tizzy. But anyway, y'all got me reading the FU, so there's that. And this is, okay, so this is Brian Steele's motion on the ex parte from Brian Steele to Judge Glanville on the 10th. Yes, okay. Interesting. Okay. All right, so now let's go ahead and jump over here. Let's go ahead and jump over here and look at, man, I am really trying to work on this. I tell y'all, I'm trying to get better. Let's do it like this. Okay. I apologize, but my eCam is looking real crazy tonight. All right, so we heard Adrian Love. So now let's go back and listen to Brian Steele. Now, Brian Steele, he submitted a motion as well, but it was on time. So let's bring that back in. All right, here is Brian Steele. You see that this was issued on today at 4:38 p.m. Just a little bit on time, right under the gate. All right, the buzzer beater. Let us go. Let us read. And what are we reading today, Jason? We're reading the Superior Court of Fulton County, State of Georgia, Georgia versus Jeffrey Williams. And here we go. All right, I was just talking about Adrian Love, so I got to be consistent. Brian Steele and these titles, man, these titles are serious. Hey, by the way, let me take a little sidebar. See what I did there? When I say Brian Steele is savage, or I say he's petty, or anything of that nature, I am saying it, I know it sounds weird, but I'm saying it as with the most utter respect. I do believe he has earned the title of Georgia's best criminal defense attorney, bar none. I esteem him. I'm saying that he's petty. I'm saying that he's a savage. I'm saying that he's a beast only in the context that the way he handled yesterday's motion and supplement and such of that nature was masterful. It was so well done. That is what I'm saying. Because I actually had a couple people comment that I was being rude to Brian. And I said, please understand. I thought I made it pretty clear if I was ever in trouble, I would like to be able to afford Brian Steele and so on and so forth. I thought I made that clear, but I want to make it clear again, just in case people might not understand how I'm addressing Brian Steele. Because guess what? We're reading a motion for a fair trial, as well as a motion for a list of dates, persons who participated in any ex parte communications with the court and the topics of same. Motion for the mistrial based upon judicial and prosecutorial misconduct and thus bar retrial. This is wild. So what's he saying? He's saying that I know that y'all had one ex parte meeting. I want to know what other kind of parties y'all been having and who was at those parties and what did y'all talk about at those parties. So you know who's going to get tapped in. That's right. Weaver. She going to get tapped in. I hate it because I think she probably is just trying to do her job. And now she's getting suckered into this shenanigans. Comes now Jeffrey Williams by the thorough undersigned counsel and hereby files a motion for a fair trial as well as a motion for a list of dates and persons who participated in any ex parte communications with the court and the topic of same. Can you imagine? Let's say, I think most of us agree that they probably have done this before. What if there was like 5 of them? Just, 5 meetings and they had them, maybe what if those were the meetings that were reasons why the comfort breaks were so long? And sometimes when they had like an hour lunch turned into an hour and 45 minutes, what if those were the ex parte meetings? Or maybe it was during those late starts. What if? Who participated in any ex parte communications with the court and the topics of same motion for mistrial based upon judicial and prosecutorial misconduct and thus bar mistrial. In the above referenced case, in support of this motion, Mr. Williams shows as follows. Mr. Williams is innocent of all crimes in the above referenced indictment. You know why he did that? Okay. I'm trying to get into the mind of Brian Steele. You know why I believe, Jason, pre-K law student, why I think he did that? Because at this point in the game, they can't prove that he's not. They've muddied the water so much. They've gummed up the machine so bad. He could sit there and say that whatever he wants. They can't prove it anymore. They can't. And I think he's only adding more gum to the system. Like I told you yesterday, he's dragging them into some deep, deep water. They're not ready. They're not ready for this. We just read Adrian Love's reply. She's not ready for this. She's, as the kids like to say, she's not built for this. Let us continue. From the inception, this trial has been constitutionally unfair as the court has failed to be impartial to Mr. Williams and or his counsel and has been objectively biased in favor of the prosecution. Some examples of same include, but are not limited to the following. Okay, so remember, Adrian said he got chided. That's one thing. And then the whole contempt thing. Those are the only two things where Judge Glanville addressed the defense. So let's see what he says. Prior to opening statements, this court ordered all parties to share with each other any demonstrative aids that they would seek to display to the jury during opening statements and were to begin on Monday, November 27th, 2023. Wow. It's going to be a year. So that objection could be made prior to the presentation of the opening statements. See this YouTube video, and you got the link right here. On Friday, the 24th of November at 4:58, Lawyers Love shared her proposed demonstrative aid via email. During opening statements, however, Lawyer Love showed a completely different, never before seen demonstrative aid, which was a clear violation of the court's order. But I thought, according to Adrian Love, they didn't have anything like this. I'm just saying. The court denied, here's the link, and it's got the timestamps. The court denied Mr. Williams' timely motion for mistrial, see example below, and there were no consequences meted out by the court for Lawyer Love's intentional misconduct. Let's continue. Number 2. And of course, these links right here, I'm not going to pull up each video, but let me grab it real quick. All right, there you go. So I did drop both of those, both of these motions and the such that we're reading in the chat so you can check them out for sure. And please check out the videos. He's already gave you the timestamp so you can kind of see what's going on and the such like that. And a lot of them are pretty short. Well, as soon as I said that, I see this one is like 40 minutes. My bad. Most of them are short, not all of them. During the same opening statements, Lawyer Love defied another court order by introducing the jury to undersigned counsel had represented other people charged in the case. And we see that already right there. Specifically during her PowerPoint presentation, Lawyer Love highlighted to the jury the undersigned counsel represented co-indictee Blaylock. Again, there were no consequences meted out by the court. And he gives a timestamp so you can see it. So remember, Adrian Love said that this is only about being chided one time and the whole conduct, the contempt thing. So now we're on the third example. That's not one of these. Do you think Adrian just might have forgot? I'm just wondering. Just seems interesting. Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting the jury. that witness Mr. Bean was taken to Grady Hospital by police directly from the scene of his arrest on September 11th, 2013. At a bench conference, Lawyer Love falsely stated that she had evidence on her table to prove that undersigned counsel fabricated evidence, as Mr. Bean never went to Grady Hospital on September 11th, 2013. And then you got the links right here. And there's several of them here. Lawyer Love's allegations against undersigned counsel were proven beyond any doubt to be totally and knowingly false. Yet, the court did not admonish Lawyer Love at all for falsely accusing another member of the bar of being untruthful. And you can see the link right there. So this is now the third example. But remember, Adrian Love said that there's only been 2. All right. And we actually haven't heard the 2 that she said. Over Mr. Williams' objections, with the state was attempting to introduce a January 26, 2015 social media posting about a co-indictee's Garlington's account during the testimony to Detective Gaither. Lawyer Love told the court that only Mr. Williams' voice could be heard in the video audio except for one other voice saying words like "yeah" in the background. Undersigned counsel told the court that Lawyer Love was incorrect and that several persons' voices were audible on the social media posting. Lawyer Love continued to falsely accuse undersigned counsel of misrepresenting the facts to the court. Of course, Lawyer Love was proven to be untruthful in her false allegations and wrongdoing against undersigned counsel. Although it was objectively proven by that Lawyer Love was falsely accused another member of the bar of misconduct and lying to the court did nothing to admonish Lawyer Love. This pattern of permitting prosecutorial misconduct illustrates that the court wrongly favors Lawyer Love and that the state of Georgia in this case. See the YouTube video here. I do want to stop right here for a second before we get to example number 5. Yesterday, I really feel like when you go back over and read what Brian Steele submitted yesterday and just kind of read through it, I think you'll clearly see he's setting, first of all, he sliced and diced and Ginsu'd Glanville like nobody's business. He got Glanville in the trick bag zipped up, tied up, is ready to go. But he also did that to Adrian Love as well. And I think he was kind of warming up. Yesterday was totally Judge Glanville. Okay. Judge Glanville caught a lot of smoke yesterday. But Adrian caught a stray or two. Today, all his attention is on Adrian Love. You don't even hear Hilton's name in here. But I mean, if you do hear it, it's you definitely hear this is against Adrian Love. And like I said, I believe he's been storing this up for the whole time. Glanville, he's been storing that up. Adrian Love, he's been storing it up, and he is unleashing a high level of you were not ready for this. Continue. Number 5, Jason. On Thursday, June 6th, 2024, as well as on Friday on June 7th, Lawyer Love falsely accused the undersigned counsel of purposely extracting and tampering with jail recordings of Mr. Copeland. This was another knowing malicious false allegation by a Lawyer Love. The court remained mute and failed to admonish Lawyer Love. I really think the problem is that the thing that's going to be stinging is they actually have the evidence right here. If he was just saying it without evidence, if he was just saying it like, trust me, he really did say something mean, but you actually got book, chapter, verse in context, come on, man. This is going to be a mess. On Friday, the 7th of June, Lawyer Love falsely accused counsel for Mr. Copeland of violating the ethical duty of their client. The court remained silent while Lawyer Love hurled more false allegations, and you can watch it right here. Ooh, and you know it's probably spicy. I'm kind of tempted to watch this one because you know Adrian Love was acting a fool. You know it. You know she was acting up. Okay, maybe we will. Hold on. And now number 7. In the jury's presence, on separate occasions, the court wrongly accused undersigned counsel of being unprofessional as well as unprepared. This is the one that she talked about. So this is number 7 when Adrian said there was only 2. I'm just saying. Both allegations are completely false, yet the court's bias is so deep that the court refused to instruct the jury that the court's declaration was completely wrong on both occasions, and undersigned counsel was neither unprofessional nor unprepared. And I think we all saw that one. This is real long, my goodness. And here's another one. The court's overly prejudicial and improper conduct towards Mr. Williams and or his counsel, and its refusal to instruct the jury to disregard the impermissible and false allegations, as well as the court's failure to apologize for its baseless claims, proves bias of the state and prejudice against Mr. Williams and his counsel. These above few examples raise reasonable questions concerning the court's partiality and bias against Mr. Williams and his counsel's efforts to obtain a fair trial and a fair tribunal without prosecutorial misconduct. This is, again, I shout out to AV to the 7th power. I think she was, because she's in law school at the current moment, and she was talking about how well this is written, how legally, how this is some high level legal writing, she said. And I believe her. I've heard other people as well say that this is wonderfully written. I guess you got to be a lawyer to deeply appreciate it. I can feel it though. I can feel there's a level of deepness here. I thought it was really very poetic yesterday, with the call to action at the end of every block and such like that. So let's continue. This court's impartiality is objectively questioned, and the court must be recused. See this example. This court has falsely and wrongly accused undersigned counsel of being unprofessional and unprepared in front of the jury. Neither claim has any modicum of truth. The prosecutor sat silent as the court wrongly and falsely accused undersigned counsel of improper conduct in front of the jury, all prejudicing Mr. Williams. The court has violated the duty of neutrality and impartiality that it was sworn to undertake. See this example here. Even knowing that the court has falsely accused undersigned counsel of being unprofessional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper and highly prejudicial comments. This conduct shows that the court is biased against Mr. Williams and his undersigned counsel, and favors the state, as no unbiased judge would not correct such a serious misstatement made in front of the jury. The bias of the court is objectively proven. And then it gives you another link. He said, look, I'm going to show you exactly what I'm talking about. This is amazing. To date, the court has done absolutely nothing. That's savage right there, y'all. That's savage right there. That is my goodness in the morning. To this date, the court has done absolutely nothing to stop lawyer love from continued misrepresentations, abuse of others, and false allegations. See what I mean? Hilton is not even in here. He is going right at 88 Love's neck. He's going right for the neck. Instead, on occasion, the court speaks in generalities and reminds both sides to be professional. And he gives an example here. This one's pretty short, though. I'm not going to do it. I kind of want to see what it said, because it's really short. All right, let me see. Since y'all want me to. I was at length. That was the time. Oh, man, we got to start from 0? Oh, I thought I was going to jump to it. Oh, come on, Brian Steele. You let me down, my brother. All right. What page was I on? I was right here. Oh, no, we was on 7. All right. This is not a both sides issue. This is a one-sided issue resulting in prejudice to Mr. Williams and a violation of his constitutional right to a fair trial. Mr. Williams languishes in jail. Is he languishing? Come on, I love it, Brian. I am here for it, man. He said he is languishing in jail without bond since his arrest on May 7th, 2022. Mr. Williams has been and is being denied his constitutional right to due process, a fair tribunal, and a fair trial based upon prosecutorial misconduct and judicial misconduct. The court has exhibited a pattern of bias in favor of the state and against Mr. Williams and his undersigned counsel, and the court has failed to admonish Lawyer Love to prevent her past and continuous misconduct. This failure to act by the court has emboldened Lawyer Love to persist in engaging in misconduct. I'm telling you right now, Brian has been saving this. Brian went old school Stone Cold Steve Austin on her. He done opened up a whole big old can. He keep calling her out. And he's not even calling out Hilton. Hilton doesn't even exist in this thing. The court has effectively, here we go again, joined the prosecution team by permitting Lawyer Love to defy court orders without consequence. The court has imposed absolutely no sanctions to stop or deter this prosecutorial misconduct. As a result, Mr. Williams has not received constitutional mandated fair trial, does not have a fair tribunal, and his due process rights have been repeatedly violated because of the prosecutorial and judicial misconduct. I'm here for this. Because the state has blatantly violated Mr. Williams' rights, they have goaded Mr. Williams into making motions for mistrial, all of which have been denied. And the above few examples are egregious and cast a dark, ugly stain on Georgia's justice system. Well, at least he didn't besmirch the whole country again. He had the whole country under the cloud yesterday. Let's see, maybe we'll throw him under there again. The below further captures the violations of the law that Lawyers Love, and Hilton, and the court display there herein. All right, so Hilton's getting an honorable mention again. On Monday the 10th, the court along with the Lawyers Love and Hilton, engaged in an ex parte meeting with, among other persons, previously sworn witness Mr. Copeland, for whom the order of use immunity had been issued on the 7th of June. No notice of this ex parte meeting was provided to any attorney for any of the accused on trial. In fact, the accused and the counsel were wholly unaware of this Star Chamber meeting, this ex parte meeting, this secret squirrel shindig. I just wanted to try that. Okay. Meeting was occurring and had occurred until well after the fact. Mr. Copeland had previously been called to testify on Friday, the 7th of June, asserting his Fifth Amendment rights in front of the jury, and was held in contempt and incarcerated until such time as he agreed to testify pursuant to the order granting his use immunity. And we got that right here. Once undersigned counsel confronted the court with the motion as to why the court held an impermissible ex parte meeting on Monday, the 10th of June, the court and the prosecutors eventually admitted to open court that this ex parte meeting had in fact occurred on the morning of June the 10th. This admission occurred only after undersigned counsel revealed, based upon information and belief, that this impermissible, illegal meeting occurred. Undersigned counsel proffered that statements were made to and in Mr. Copeland's presence by the court and or Lawyers Love and Hilton, all acting in concert, asserting that Attorney Melnick failed to represent Mr. Copeland's interests and explaining the amount of time that Mr. Copeland would be held in custody unless he testified as urged by the Lawyers Love and Hilton and the court. On June 10th, the court denied undersigned counsel's request for a transcript of the improper, unconstitutional ex parte meeting and denied the undersigned counsel's timely motion for mistrial based upon, including but not limited to, Mr. Williams' federal and Georgia constitutional and statutory rights that included the right to due process, a fair trial, a fair tribunal, ethical prosecutors, and the right to be present at every critical stage of the proceedings. That's what I'm wondering. Like, how did she get away with saying that they didn't need to be there? That's the part that's just totally amazing. Instead, the court held undersigned counsel in contempt and ordered undersigned counsel to spend 20 days in jail, despite the assertion that the valid privileges in declining to answer the court's demand to reveal the supposed source of the information about the ex parte meeting. In the afternoon of Monday, June 10th, lawyers Love and Hilton sat mute and permitted this travesty of justice to continue. Later, lawyer Love argued that the ex parte conversation with sworn witness Copeland, Mr. Copeland, was ethical, just, and proper, despite it violating multiple constitutional provisions, judicial canons, and rules of professional responsibility. And there's all of the timestamps. So when you click on it, you got to know all your timestamps. That's crazy. Okay. Furthermore, Mr. Williams requests a list of persons involved, the topics of the same, and a transcript of all the ex parte meetings, if any, conducted by the court and involving anything to do with this case and trial. Additionally, Mr. Williams also moves that any document that is filed under seal to be reviewed by a neutral judicial officer to determine whether the same needs to be unsealed and shared with Mr. Williams under statute and constitutional provision. That, again, he is dragging them into some deep waters. So now anything that's been sealed by the court, any kind of meeting, any kind of documents that have been sealed, he's now saying that they need to be able to see everything. And allow a third party, non-involved judge to see it in order to determine if it needs to be seen. He's dragging them into some deep, we are at some high level. We are well in over our heads here. Wherefore, undersigned counsel respectfully requests that lawyer Love be barred from uttering false allegations or disparaging words towards another. Lawyer Love conduct herself with professionalism and full compliance with the Georgia rules of professional responsibility, which govern the conduct of lawyers in the state of Georgia, if able, and a mistrial be declared based upon lawyer Love's, lawyer Hilton, and the court's failure to protect the above stated constitutional rights, as well as Mr. Williams' right to be present under Articles 1 and Section 1, Paragraph 12 of the Georgia Constitution, its federal counterpart. The right to confront witnesses, right to a fair tribunal, the right to a fair trial, right to due process, right to be present present a defense and call witnesses. This 10th day of July, respectfully submitted. Wow. That is amazing. This is wild. To say that this is like totally unheard of and just like this is on a whole other level. Hey, that's me twice. We'll get it together. I promise. I'm going to get that fixed. But to say that this is something new is an understatement of the year. It is a total understatement. This is amazing. Amazing. But before we get too far afield, I want to thank Retired for the very gracious super chat. What does he say? What does Retired say? Retired says, Jason, fix this thing because this thing is out of control. That's what Retired says. Hold on, let me get this tight. Why is this like this? Thank you for the very gracious super chat. Now I got to get this thing fixed in here. One second. Oh, there we go. Dude, I have no idea what happened there. All right, let's try that again. Thank you so much for gracious super chat. Let's see what you said. You said, Take a poll. How many ex parte meetings have been held? I say a minimum of 3. Okay. Let's see. What do y'all say? Let's see what y'all saying. All right. How many ex parte meetings do you think have happened? All right. Give me a second. Let's go. All right, everybody, get ready. Okay, I'm gonna start with 3. All right, everybody, jump on. It is hot now. How many ex parte meetings have there been? 3, 4, 5, or more. Hey, Fred, thank you so much, man. Grace and peace, brother. Thank you so much for the very kind super chat. I appreciate y'all. All right, let me fix this. I'm having a lot of technical issues today. I'm very embarrassed about all these technical problems. Why is this looking like this? I tell you, man, you cannot win for this. Technology is going to keep hitting me in the head, I tell you. All right, let's see if I can get this. That is definitely not going to look right. Okay, so I think I got it fixed. Let's see. All right, let's try it. It's still outside the pocket, though. Indiana in the house and waiting. All right, let's see what we got. Thank y'all so much. I appreciate everybody who's come through tonight. Always, thank you, Transplanted Texan. I appreciate you so much. Good to see you, Robin. Always good to see you. That's a great question. Where is Anna Cross? I have no idea. But I like what you're thinking because I don't know where she is. So I see Shar in the building. Thank you so much, Shar, for stopping by tonight. Let's see how many people have voted. Wow, y'all do not have any faith in this judge at all. Wow. So at the current moment, most of y'all said there's been more than 5 ex parte meetings. Well, thank you, Foster. Thank you so much for the love. I appreciate it. Even though I don't know what I'm doing with why my text is all jacked up. I'm going to get it figured out. I feel like AD Love now. So I can't even talk smack about it now. Okay, let's see how this looks. Okay, that's all right. But this is like outside of the scope, though, for some reason. I don't understand what happened. It's too big. I don't know what happened. All right. Yeah, it's clear witness intimidation. I don't think there's any reason to think that it's anything but. All right. What's going on, Liv? Travis, hello from New Jersey by way of East Cobb. There we go. Oh, thank you so much, Robin. Make sure you hit that like button. Make sure you do that. I like it, Mike. Thank you so much, Mike. By the way, Mike is I know you're a content creator, Mike, if I'm not mistaken. Please, feel free to drop your link in the chat or give us the name of it so the moderators can make sure they drop your link in the chat, my friend. Love to see what you're doing over there. Hey, Jean Lee, good to see you. All right. And hello to you. Thank you so much, love. There she is. What's going on, TJ, the advocate? How are you? All right. Corey's in the building. What's up, man? What is going on? Yeah, so y'all are, yes, so Love, Hilton, and Judge Glanville. Let me find that real quick. They are all on the witness list now. They've all been upgraded, upgraded their flight to now they are witnesses on the trial, which I'm pretty sure I feel comfortable in saying they did not want that smoke. All right, let me find it real quick so you can see it. Jumping over to Thug Daily. Mm-mm. Oh, where is it? Where is it? But yeah, I just thought that was wild that he went in. He said he was going to do it. So now they are witnesses, and I don't know how that works. So if they're witnesses, are they able to deny that they don't want to be witness, or what? I don't know how that works. All right, let's see where this is. It's not on Thug. All right, let's see if Cat has it. Hmm. Why does nobody have it? That's wild. Okay. I'll pull it up in a second though. But anyway, they are now witnesses, which I think is going to be pretty comical. But I don't think this case is going to go any further. I think we've reached the climax of insanity. I don't think this case can go any further. I just don't think it can do it. Now they can surprise me. They can pull out a Mickey Flynn and keep dragging this thing around, but I don't think it's I don't think it can. All right, here we go. Here we go. I just don't think this case has any more steam. It's a wrap. It's over. It's done. Where are his motions? I'm looking at Joseph Papp. He has a great Twitter page as well. But he had it on here earlier, and it was just a screenshot, so I couldn't download it, and I don't see it anymore. Okay, I'm not gonna keep you out while I'm sitting here looking like a crazy man. All right, so if I find it, I will load it into the description because I got to put this in the description anyway. Hey, Republic Room, good to see you. He really didn't even want to tell TLA his age either. You heard that yesterday too, when TLA asked him. By the way, Woody was on the lead attorney show last night, and they had a good conversation. I thought it was insightful, and TLA just out of the pocket said, "Hey, how old are you?" And he was holding on because I was thinking he was gonna say grown, but he told him how old he was. And basically, he's like 32 years old. He said he didn't know how old he was. He says roughly about 32 years old. And if you do the math, listening to him, 32 sounds about right. My head is sweating for some reason. All right, that looks okay. Let us go. Let us go. All right. So, lots of good people, lots of good family reunion going on in the chat. If I missed you, please don't hold it against me. Please don't hold it against me. I'm going to just jump right here. Good to see you. Thank you so much for stopping by. Green eggs on ham. I appreciate it. I like that title. I like that name. Let's go. Let's go. All right. All right. So Karen is my name, says, oh, this is still not fitting in here correctly. What am I doing wrong? I feel like a rookie. I feel like a total rookie. That looks crazy though. What did I do to this? This looks bananas over here. Why is it looking like this? Note to self, stop messing around with Ecamm. Stop messing with it. All right, this is just, it's like not allowing, hold on one sec. I think I got it. Oh, this looks crazy. It's like it's not centering correctly. That does not look good. Let me see if I got this right. Let me click on this one. Okay, there we go. I think I got it. Praise the Lord. Because it was a good comment too. What does Karen say? Got it. Okay, got you. I'm catching up. The entire meeting was not taken down. Kayla Bumpus said there were conversations off the record, but she felt they didn't add substance. I got you there. But also, it seems pretty clear that there were other things that were on the record that possibly weren't in there as well. So, or were redacted from there. So it's unfortunate because I'm like, why can't we just have the whole thing? Like, just let us have the whole thing. It is what it is. Can they get immunity? You can get immunity if you like this video, but can they get immunity? I don't think he's asking them anything to necessarily incriminate themselves. I think he just wants to show, in my opinion, he just wants to show that there's a level of bias. They're not being impartial, and they can't be judge and prosecutor in this trial. I think that's all he wants to prove. So I think if they try to plead the fifth or try to do something like that, it'll only actually make the case worse, in my opinion. Probably just wonder where she was, not in relation to YSL, probably. I'm not certain I know what that one is. I feel like I might have missed something there. Phil says that this will not end with Cross. I don't see how it doesn't, but he's in the loop down there. Okay, I would have to hear why Phil says that. I don't think Cross is going to get Kraus is going to get disqualified or have to recuse herself. I don't think that is going to be the case. I think what's going to happen, though, it is going to have to go outside of the Fulton County office, or I think that's going to be pretty much given, in my opinion. Love on the witness stand. Oh my goodness, that sentence right there would cause them to win the case because she doesn't know how to conduct herself professionally and doesn't like being questioned. You're correct. 100% correct. Whoa, what's going on? Long time no see. Honest Youth Pastor, thank you so much for stopping by. What's happening, man? How are you? I hope you're still here. I think you are. You might still be here. Well, good to see you. Thank you so much for stopping by. If the Honest Youth Pastor, he is a youth pastor and he's honest. If the moderators, if you could drop his link in here, it'd be great. He does some great sermon reviews, looking at doctrine and all that. I believe he's looking at Andy Stanley recently, if I'm not mistaken. So he's done some great docuseries as well. Excellent content creator, very good content creator. Thank you again, Honest Youth Pastor, for stopping by. Appreciate you. Audrey, good night. It's a good time for bed. I understand. I was looking for just the Brian Steele, transplanted Texan. I was looking for Brian Steele's new witness list. I had it, but it was a Twitter post. It was not the PDF, and I was just looking for it and I couldn't find it. I could probably look now while I'm sitting talking smack, but I didn't see it. I know it was on like Thugger Daily at one point and a couple other sites, and I don't know where it went. Just user error more than anything else. I'm telling you, I'm struggle streaming today. I'm struggling. Love on the Witness Stand is a hit pay-per-view. That's a good point. I mean, they would pay for the trial if we had to pay to watch Adrian Love being questioned by Brian Steele. But I also would say, hey, Judge Glanville being questioned by Brian Steele and Sharp and Adams. I'm sorry, that's going to be amazing. Sign me up for that. That would be a great pay-per-view. You're right. Now, granted, don't make it too expensive because this trial is going on for a long time. So don't make it too expensive. But yeah, I'd pay for that. I would. You guys are a trip. Okay. He said, I had heard that they were struck from the witness list by Krause. Did that not happen? When I saw it at literally like 5 o'clock, they were still on there. But could something have happened now? It's like 9 o'clock. Absolutely. So I'm looking diligently. I'll find it. Okay, let's see. Yeah, I don't see it. Maybe something did happen to it. Maybe that's why I don't see it. That could be true. All right, so at the current moment, most of y'all think that there were more than 5 whatchamacallits ex parte meetings, which is crazy. That is crazy. That is not a good look that so many people believe that they had that many ex parte meetings. And they might have, truth be told. It makes sense. A lot of us, that makes sense. Like, yeah, I probably did. Katna Williams has a witness list. I'm looking. I jumped over here to her page, and I don't see it. Sorry about that. I didn't mean to do that. All right, look in here. Look in here. Yeah, a lot of people are saying that the transcript has been redacted. So, if in fact it was, then that is unfortunate. Because you wanted to believe that they're going to they're going to do the right thing, and of course, now they didn't. All right, so let's see. Cat had it. Let's see. Yeah, I see it right here. But where was that? Hold on one second. All right. All right. Okay, I see it. Now I know where to find it. What I'm looking for, real quick, I just want to show you how the new witness list. But I don't want to don't want you to get too happy because somebody's already mentioned that they might have struck them down as witnesses, which is interesting. I hope they didn't. I hope they leave them right on there. Mm-mm-mm. Shaggy said go with 9. That is crazy and probably right. But still, that's crazy. I do think they've gotten very comfortable. So I do believe I'm not surprised. If if we came out and heard that they did have more ex parte meetings, I don't think I'd be surprised. Okay, so the list that I see here, okay, it is a updated list, and I don't see Glanville on here. Wait, that's crazy. No way. Are you for real? Got me over here saying my ABCs. Like, okay, where's Glanville? Like, where's Glanville on here? I don't see Glanville on here, or Love, or Hilton. But it was literally on here. Maybe that's why the list was so hard to find. Okay, I'm gonna leave it alone because I'm not gonna keep y'all long. Everybody, I want to thank you so much. I appreciate y'all. This has been a lot of fun, and I'm glad y'all enjoy hanging out. It's still on Thug. It's still on Thug Daily's page. Really? I'm looking. I'm looking on Thugger Daily. Tasha. Let me see. Maybe I'm tripping. Which would not be uncommon. Which would not be unbelievable. Okay, I'm looking here. Drop me the link, please, Sasha, because I don't see it. Oh, there it is, right there. Thank you, Texan. All right, let's see what we got. Okay, here we go. I am so sorry. Thank y'all so much, man. Y'all are patient. Y'all are patient saints. I appreciate you. All right, here is the witness shopping list. Let me pull myself back in here. All right. All right, so we're scrolling through here. There's one right there, number 16, witness number 16, Judge Glanville. Then witness number, witness number 26, Simone Hilton. And then lastly, if they go in order, last one is Adrian Love. Gonna get that love. That is gonna be crazy. Let me drop this. The link is in the chat already. So thank you so much, Texan. I appreciate it. Thank you. I don't know why I was drawing a blank like that, but I appreciate you coming through in the clutch. Yeah, this is gonna be wild. Witness 16, 26, and 38. That is going to be amazing. I don't think it's even going to get there, though. I'm just going to say it. I don't think it's going to get there. It's going to probably get pitched out. It's going to probably get just pitched out. But I do think it's funny, though, for sure. There we go. So, my good people, thank y'all so much for hanging out with me. I'm glad y'all enjoy these readings and such like that. I'll try my best to be a little bit more professional. I don't know what happened with my eCam. It was working fine, and I log in and go live, and it goes all cattywampus. So, but I appreciate y'all. Hopefully you all enjoyed that. You got some good stuff out of it. Again, I left all the links in the chat. As soon as I get done, I'll upload them into the actual description of the video. So you have Adrian's response as well as Brian's response. And let me grab that Thugger Daily one too. I'll put that in there as well. So you have the whole robust story, everything that's going on, all these shenanigans going on out here in this story. It gets tossed. Are you saying that? Oh, or the Supreme Court. I got you. Yes. I do think it's going to end up going to the Supreme Court, Georgia Supreme Court. I hate it like that, but I think it is. Okay, I saw those as well, Tasha. I wasn't familiar with the names. I do see Esquire and such like that. I don't know who those people are. So I'm going to assume, since we know those three people, they are in. Oh, you know what? Let me check something. Okay. Yeah, I don't know who these people are. Lawrence Zimmerman, Esquire. I don't know who that is. Maybe I'm sure they could be, because there's another Esquire right above Hilton. I'm sure it could be part of the prosecution team. They had a pretty deep bench. So, I mean, it could be. I just don't know. But good catch. Good call. Excellent question. Thank you so much, Green Eggs on Ham. I appreciate you. Green Eggs, no ham. I'm sorry. I read that wrong. Okay. Green Eggs, no ham. I got you. I see what you did there. I see what you did. I'm glad you like it. Thank you so much. Emma said, I wasn't expecting much from the state's response, and Love has not proved me incorrect, especially in light of Attorney Steele's superb and articulate wording in all his motion. Back to class, Miss Love. Wow. Man, Shoe Smith, you are not playing. You team Brian for sure. But I think it's true. I think Brian did an excellent job. And I think it's kind of cool because I'm not a legal eagle. I don't know all the ins and outs. And I was impressed with the writing yesterday. I'm like, this is fantastic. And now to know, even to hear lawyers talk about it and how they were fawning all over it, I'm like, yeah, I knew that. I knew that. So, but then you go read Adrian's again. Not mad at Adrian, but that was something I probably would have wrote. That wasn't turning the legal dial at all. So, always great content. Have a good night. Thank you so much, Shaggy. I appreciate you. Thank y'all very much, every last one of you. I really appreciate it. Let's end on this note. If you do like this type of content, make sure you hit the like button. That's how you get in. That's your key to entry. That's your barrier to the ex parte, to be a part of the parte, which is the best live chat on the planet. I thank you all so much. Thank you so much to the moderators. Thank you to all of the gracious, very kind super chats and super stickers, all that kind of good jazz. I appreciate it. The whole process, Fred says, we're gonna end with Fred. Fred says the whole process has been a waste of taxpayers' money. That's why I keep calling it a wealth transfer. I think all of this has been a wealth transfer. Now, if somebody had actually gone to jail, if this case had actually gone to the jury, maybe so. But at the moment, I feel very comfortable. This is nothing more than a wealth transfer. Come, what are you, ladies and gentlemen, boys and girls? Kat Not Williams in the chat. Good to see you, Kat. How are you? Thank you so much for all that you've been doing. I did siphon the two motions from you because you did such a great job of pointing them out. Thank you so much. If you could, if you oh, and Kat is coming here bringing gifts. Oh my goodness, Kat is dropping gifts as well. If you could, Kat has just dropped 5 Dear Woke Christian memberships. If you received one of those, can you please do me a favor? As a good friend of mine likes to say, please be kind, because we're down here in the South. Make sure that you say thank you to Kat, and don't just say thanks, but say thank you, Kat. Put the name on it. Be like Glanville. I love it. Oh my goodness. These can be daunting, but you did a great job, Kat. So thank you so much for coming in. Not only stopping by, but for blessing the audience. We appreciate it. Thank you, Kat. If you want, I can hang in a little bit longer. If you want to jump in, Kat, I'll drop the link. I'll give you the link if you have time. If not, it's okay. I know you've been doing a lot. So if you want to jump in real quick and chit chat about what you've experienced, what you saw, I think you had Kayla on earlier and such of that nature. If you want to, that'd be cool to have you. If not, I totally understand. But I do want to thank you all, everybody who's been hanging out with us, doing these readings. And they drop the readings late at night anyway. Probably like the last thing as they're walking out the door, they hit send. So we get the briefings at like 6 o'clock almost sometimes. So that's why these are being so late. But I do appreciate y'all nonetheless. Now, I do want to, Kat is in the kitchen. Okay, no problem. I appreciate it though, Kat. Thank you so much for stopping by, as well as for blessing us with the memberships. Thank you. I do want to know, are y'all watching that Alec Baldwin case? Are y'all interested in that at all? I've been kind of, scoping it out a little bit, looking over the fence. It seems pretty interesting. I hate to say it like this, but I feel sorry for Alec Baldwin. I don't think anybody wants to be the person to take somebody's life, especially in an accident. I can only imagine. I don't feel like he's guilty though, especially given the fact that they've already put the woman that the armorer in jail. What are you doing with him? Like, why are you even doing this to him? And again, ideologies aside, I'm like, why is he going to jail? I don't get it. So anyway, I've been kind of checking out. I don't think I'm going to do like a full deep dive into it. Maybe we'll talk about it on Sunday. Cause that'll be 4 days of, no, today's the 1st. So it'll be 3 days. So it'll be some time to look at it. Maybe we'll talk about it on Sunday just to see what you all are thinking. If you're paying attention to it, kind of peeping over the fence, checking it out between these, Brian Steele motions and these Adrian Love Cliff Notes. Maybe we'll look at the Alec Baldwin case as well, just kind of get a lay of the land. I'm sure some people have been looking at it and have been talking about it. So everybody, I want to thank you again for your patience. Thank you so much. Had a little bit of technical difficulties, but I appreciate you nonetheless hanging out with me this evening. I want to thank all the content creators that rolled through. Again, check them out. Check out Kat Not Williams. Definitely let her know that we appreciate her, what she's doing. She's doing a yeoman's job of keeping us abreast of these type of stories. So definitely appreciate that as well. Shout out to all the other content creators that stopped through. And don't forget our moderators. The moderators rock. So I want to say thank you to all of them because they keep this thing going. They keep the links popping up in the chat. They keep everybody moving in the right direction. I love it. And I really do appreciate all of y'all. So let's do this again real soon. I got this feeling. Who knows? Brian Steele might drop another motion tomorrow. But I am thinking that something's going to happen on Friday. I'm not a prophet. I'm not the son of a prophet. I'm just saying, I think something's going to happen before the weekend, whether it be some major recusal, maybe some major throw out, or maybe, I don't know, go to jail. Something's going to happen, I think, this weekend. I mean, going into this weekend, but that's just my little 2 cents. We'll find out real soon. Tomorrow, oh my gosh, how did I forget? Tomorrow, I'm having infamous Sylvia stopped by. She has been a pillar of this community in the YSL case. She's been there at court almost every day since day one. She has been involved. She's been doing fantastic interviews, meeting and giving play by play, day by day, what's going on. Tomorrow at 7 o'clock here, infamous Sylvia will be here. I'm going to interview her and ask her a lot of questions. I got a lot of questions for Sylvia. So you bring your questions too, and we'll just keep her going all night long. So that'll be a fun conversation. I almost forgot about that. That's what we're going to be doing tomorrow. So hopefully Glanville won't do anything crazy and derail the conversation, because I got a lot of stuff I want to ask Sylvia and find out a lot about her. So hopefully we'll have a chance to do that tomorrow. So everybody, thank you again. Let's do this real soon. Matter of fact, let's do it in a couple of hours. We'll do it tomorrow. How about that? Everybody, until next time, grace and peace. Take care. See you soon.